Well, hello folks, Alex Woods here, litigator at Redwood Legal. Now, this is actually quite a tricky process, and you may regret ever having brought a claim against an opponent. When you get an order, you kind of expect that you're going to be able to get your money back, but I don't know, perhaps 1 or 2 times out of 10 you're going to run into difficulties, and you are going to need to bring enforcement proceedings. I'm just going to give a general overview initially, okay? Now remember to check the date of this vlog to make sure it's reasonably up to date, and also your case will have specific features such that really you need legal advice tailored toward the individual circumstances of your case. It's not a pitch for business, it's just a fact of life, honestly. Anyway, nevertheless, to sort of set sort of a general overview of the law, I think, is helpful, and it helps you to navigate your way around and make some sort of certain preliminary decisions about what to do. And I hope also you'll be able to make some decisions about whether or not to actually bother doing anything, because as often as not in life, you have to make decisions about what battles to fight and what not, and you have to be sort of commercially savvy about things. Okay, so I will use this mini vlog to give you a general overview of enforcement proceedings, debt recovery, and then I'm going to go on and do a second vlog for those who are interested in more detail. And in that second vlog, I'm going to drill into the details of a particular case that we've run at Redwood Legal and put some sort of flesh onto the bones. Right, so you are confronted with proceedings. This is in relation to where you've brought proceedings and you've got an order of the court, okay, that your opponent pay you a sum of money typically. Now the question is going to be, what sort of type of enforcement proceedings do I go for? And there are a number. Charging order, okay, you can actually apply to the court to get them to put a charge on your opponent's property. Now that's appropriate in high value cases. If you're going to ask me what is high value, I don't know, but certainly well over the £10,000 mark, perhaps 50,000, plus, because when you think about it, a court is not going to ultimately order a sale of someone's home for a small amount of money. You're going to end up with some sort of repayment plan or some sort of compromise there. So a charging order is really appropriate in the bigger, higher value claims, typically. And don't forget that even though you may apply for and be successful in respect of a charging order, once you've got a charging order, that's not giving you your money. You're then going to have to apply for an order of sale of the property. So you can see it's beginning to become quite a big type of process, for which you're probably going to need legal advice, because where selling someone's home, a property is concerned, there are certain procedures and pre-action protocols that must be followed, or else you'll get into tricky water. Okay, the next thing is a third-party order. Now that is where you are asking the court to tell a third party to satisfy the debt of your opponent, all right? The classic example is a bank. That's a third party who owes their customer, your opponent, some money because there's, clearly some money sitting in a bank account. Now you've got to be careful about this one, because you need to demonstrate, you need the evidence. You can't just go on a fishing expedition that third party, typically a bank, has actually got the money. You might evidence that is by demonstrating that your opponent has a job and is regularly paying money into a bank account, a salary into a bank account, and it's sort of crystal clear that that current account is the one that's in receipt of the salary. Now, another form of enforcement is actually making an application to the court for an attachment of earnings order. And obviously that's only going to be appropriate where your opponent has got a job. Can't be self-employed, they need to be having a job such that you can apply to the court for an order to their employer that they pay money out of their monthly or weekly salary to you. that is an application that's typically made to the county court where you've got the judgment, which is logical, isn't it? And their local court, where your opponent resides and where the employer may reside. I will link either to this or the other vlog various useful links, because there's a lot of information already out there online, government websites as well as other websites. And I will also just provide you with sort of some samples of the typical forms that you're likely to have to use. Okay, now this brings me on to probably the main and most important type of enforcement, which is seizing someone's goods. Okay, so when you are doing this, you need to give some thought to whether or not your opponent has got, sufficient value of goods to satisfy the judgment. Now, that's not always an easy decision to make. For example, an enforcement officer, right, or a bailiff, has to actually ask permission of someone before they can go into someone's home and actually take any goods. Yeah, business premises is slightly different, but if it's the home. Also, they aren't allowed to take tools of the trade up to about £1,350. You can't take that. Now that could be someone's laptop computer if that's their work computer. However, they can take something that's in the drive, i.e. your opponent's car. Now you need to think carefully, therefore, and probably need to gather evidence, because you're going to produce a witness statement when you apply for enforcement proceedings to court. You're going to need to, think about why this is a reasonable step to take, and you think they probably have the assets, the goods worth seizing to satisfy the amount of your debt. There are certain exemptions, essential things for living. I think like one landline phone they can't take. The certain types of appliances I don't think they can take because they might starve or freeze to death. So there are certain things like that, but on the whole an enforcement officer or bailiff will know what to take. So now, in terms of the process of applying for enforcement, it is relatively straightforward insofar as you don't need a court hearing. You've got your order, you've got evidence. Remember, you're going to attach a witness statement to any application demonstrating why your opponent has failed to comply with that order or has missed a repayment, because often an order for some of the money will be commuted to a repayment plan. If they've missed one repayment, then you can apply for enforcement. So it doesn't need a hearing. There are two types of application, depending upon whether you're going to the High Court or the County Court. If it's under £600, you have to go the County Court route where you got the judgment. If it's above 5,000, you have to go to the High Court. Anywhere in between, you can actually decide which route you prefer. There are different application forms that you need to fill in. When you're going to the High Court, you have to fill in an application form, which is kind of like a two-part application form. I'll link the numbers of these forms below. And you actually send it to the County Court where you got judgment, and then that County Court judge stamps it, satisfied with the evidence you provided, and then shifts it along to the High Court and the High Court enforcement team to then execute enforcement. Should you go High Court or County Court route? Well, if you're between 600 and 5,000, it's a tricky decision. It's slightly more expensive and a little bit more, could be a little more complicated going to the High Court. On the other hand, apparently High Court enforcement officers are better than the County Court bailiffs. So I guess if it's a higher value claim, I guess if you think there's some awkwardness or likely to be some difficulties, it might be safer to go with the higher court. Whereas if it's more straightforward, just to go for the County Court route, the paperwork is easier on the County Court route, so that may be a factor. All right, so there it is. I'm not going to go into any more detail at the moment. I am going to link relevant, very helpful guides the government provide to drill into further detail about all the issues surrounding enforcement. But I will just conclude by saying that you've got this enforcement. Incidentally, you don't have to give notice of your opponent if you are going to make an application. You can make it without telling your opponent that you've made that application. Although subsequently, once the enforcement officer goes after them, the enforcement officer then has to give them usually 7 days notice that they're going to visit their house and take some stuff. You should also, before you make an application, actually write a letter to your opponent saying you haven't paid the judgment debt, you've not met the terms of the order of the court, or you've missed a repayment. That's a useful letter which you can then use to include along with your witness statement in the application to the court, whether you're going the county court or the high court route. There's complexity around this area, unfortunately. My advice is never get into this deep water in the first place. You may well need a little bit of legal advice on this, so here is the plug. Talk to a solicitor at Redwood Legal for £150 plus VAT if it's a small claim under £10,000 to get some general advice. Or if you think that you really do need advice tailored towards the circumstances of your case, the best thing is to email us documents at info@redwoodlegal.co.uk. It's a PDF in nice chronological order. It usually takes about 2 to 3 hours to advise people. Again, the hourly rate is £150 plus VAT. So if you want to drill into more detail about enforcement proceedings, specifically about seizing goods, and I'm going to apply the law to a real life case, then listen up. The next vlog will follow very shortly. Bye for now. Hi folks, if you enjoyed this video or any others in this series, then please do hit the subscribe button. Subscriptions are obviously really important to us because they help push us up those YouTube rankings and get the good word out to the general public. Click subscribe.